This is a case that hits very close to home. It's a hockey story, a hockey case, and in a city like Ottawa where everyone sort of knows everyone in the legal community and in the rinks. You found this an interesting one to share, Dave.
Yeah, Leanne, we've spoken before on the show about injuries in sports and when can you sue for an injury you've sustained and when you can't. And we've talked about inherent risks of sport and you implicitly consent to certain injuries that you might sustain in a sporting event. But recently, an Ottawa court had to grapple with that challenging question of when can you sue and be compensated for an injury that you've suffered during a sporting event.
And this is an older case, and it'll be familiar to many, but the judgment, of course.
Yeah, so it came out recently, but the incident occurred in 2012, and it was a men's rec hockey game, and so it was an on-ice incident where one player was injured at the hands of another player, and I can tell you that the facts basically are that one player was blindsided somewhat violently by another player and suffered serious injuries. Well, I have a tough time telling you what the facts are exactly because if you read the decision, there were 12 different witnesses, none of whom gave the same version of the events. And that's not because they weren't being honest, it's just different perceptions and the things happen so quickly.
Memory and time.
Memory, time, perception, and that's one of the real challenging things in these cases is just getting the facts together. So what the judge was left to answer was, at what situation is somebody going to be liable in a sporting accident or a sporting incident? And what she found was that if it's malicious, sure, if it's intentional, sure, but also if it's outside of the ordinary bounds of fair play. If it's out of the ordinary, if it falls outside of what should be considered fair play, and you injure somebody, you can be liable. And in this case, among the witnesses were the referee from the game. So the player who was the assailant actually was assessed a 10-minute misconduct. They got a 7-minute intent to injure penalty as well. So some of the facts were pretty heavily against the assailant. But it really does, for a lawyer looking at these things, it helps clarify what the test is, out of the ordinary or beyond what's considered fair play. And the other thing that really hits home is the importance of getting the facts of these cases early. Mm-hmm. Yeah, getting on top of them. And I guess the third thing, of course, is this poor fellow suffered a concussion, and it reminds us of the serious implications of head injuries and his diminished ability to work and quality of life.
And you've actually had a number of players or people who have been injured reach out, but if we should chat about the statute of limitations, if in fact you are injured during a sporting event, you know, on the ice, the statute of limitations is
2 years.
Unless
unless you're under the age of 18, or unless there are some exceptions, like, you know, let's say you've suffered a brain injury and you're not capable of commencing an action. There are certain exceptions, or you don't know the extent of your injuries, you don't know that you've been injured. I mean, those are a little bit tougher to make out. But you know, use as a rule, you need to commence an action within 2 years of the incident.